Previously on the American Justice Podcast.
Ranger Sergeant Collins informed Williams that information had come in to investigators early on in the investigation that suggested that although Williams was a married man, Brandon Woodruff's choice of a homosexual lifestyle may have been brought on by Williams' close relationship to Brandon Woodruff. Williams stated that he would be willing to submit to a polygraph examination to prove that he did not have any involvement in the murders of Dennis and Norma Woodruff, and had no type of inappropriate relationship with Brandon Woodruff.
There is an epidemic in America's criminal justice system: the prosecution and conviction of innocent people for crimes they did not commit. Welcome to American Justice. The American Justice Podcast Army works to free men and women wronged by the criminal justice system. It's not only about the innocent who have been imprisoned, but also the victims of the crimes as well. No one deserves justice more than them. And now, here's your host, Scott Pogensy.
Hello, AJ Army. Welcome back to your podcast. Last week, we finished up on the investigation in the case and closed out the book on Ranger Collins. It won't be the last time that we talk about him because he does end up testifying in trial. Although, after this episode, you'll be scratching your heads as to why that was the case. He should have been disqualified from the investigation after his unethical actions contained herein. Okay, let's get started. All right, let me set the stage for you. In July of 2007, the state and the defense are pretty much ready to go to trial. There's some small things that need to be worked out, like what the judge is going to allow in about Brandon's stripping and stuff like that, but they had set a trial date and it was tentative for the next month, August of 2007. The swearing in of witnesses was to be August 13th, but not so fast. Brandon's attorney at this point is Jerry Spencer Davis. His paralegal is Linda Guyton. Linda visits with Brandon almost every single day. She says that very early on in the case, she realized that Brandon was innocent and she was going to work tirelessly, night and day, to make sure that Brandon was either released and the charges dropped or exonerated at trial. Either way, she was going to make sure that Brandon did not spend the rest of his life in prison. Not on her watch. So Jerry Davis received a very disturbing phone call. It was from a guy named Curtis Neel. Mr. Neel is the head jailer at the Hunt County Jail. He informed Mr. Davis that he had been instructed by the district attorney's office to record all of Brandon's phone calls, including the ones between Brandon and his attorney's office. Yes, Jerry Spencer Davis's office. He was then further instructed to turn those phone calls over to the DA's office as well. For those of you not too legal savvy, this is a big no-no. The Sixth Amendment of the United States Constitution says, quote, "In all criminal prosecutions, the accused shall enjoy the right to seek a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." End quote. If you have never read the full Constitution, you really should. It's not very long, and it won't take you very long either. However, what governs the laws and how defendants are treated in this country is more the hundreds of years of what they call case law. This is when something adverse happens in the case and it's brought to the Supreme Court to interpret the Constitution. For example, if you notice, in the actual text, it only says that the defendant is to have the assistance of counsel for his defense. Does this mean that he's guaranteed to have an attorney? If he is the state obligated to pay for it? What if he's convicted and then he needs to appeal? Is he guaranteed the right to counsel post-conviction as well? Does the state have to pay for that also? All of these questions have to go before the Supreme Court so they can interpret the Constitution. Well, over the years, they also interpreted that the Sixth Amendment guarantees the defendant not only the right to have counsel, but that it must be effective counsel. I'm sure you've all heard the phrase, ineffective assistance of counsel. Well, the Supreme Court guarantees that you have the right to not only someone that's competent, but that your communication with your attorney must be in private. You also heard the phrase attorney-client privilege? Exactly. Imagine what would happen if your own attorney could be called as a witness against you. No defendant would ever tell their attorney anything. However, guaranteeing that communication is private and privileged helps guarantee that effective assistance of counsel. Now, after all of that, imagine that your conversations with your attorney were being monitored by the prosecution. As you can imagine, that would not only violate your right to effective counsel, but would automatically give the prosecution your entire playbook for your defense. As you can imagine, the rights that we hold so dear to us as Americans, those rights that we have fought and died for, are essential to our rule of law. But you don't have to take my word for it. Here's State District Judge Keli Aiken. I caught up with her at a reading of the Declaration of Independence on the Hunt County Courthouse steps way back in 2018. Remember when we could all stand next to each other and not be afraid of cooties? Here she is telling us how important the Constitution is, and specifically the Bill of Rights, and how important it should be to all Americans.
Well, the Declaration of Independence was the initial assertion of freedom and independence away from a monarchy, which would be England, to establish the United States and to start our federal government. It's one of our original founding documents that created the circumstances for the basis of the government we now have today. The Bill of Rights is a separate document that later gave specific rights to individuals who live in our nation.
Oh, really?
That gave us rights that couldn't be taken away by a government or couldn't be lessened or changed by any governing body or by any public official. Okay. So the Bill of Rights, in terms of importance to individuals, is that today it still holds true, every word of it, in terms of the individual rights and freedoms our citizens have. But the Declaration is historically important because it was one of the founding documents that started us along the way of establishing our Constitution and later Bill of Rights, and gave us the rights that we hold true today.
Okay, so the Bill of Rights was basically is what kind of established, I guess, our laws and like stuff that we go by and stuff like that, right? And more than the Declaration.
Yes, the Bill of Rights established specific laws to the individual.
Okay.
The Declaration was more of a statement as a country to a foreign oppressor, which we consider was the monarchy of England.
I see. Okay.
Yes.
Wow, seems pretty important, right? Remember her words. We'll get back to them in a little bit. Okay, I said all of that to say this. This is exactly what happened to Brandon. The only way that Brandon had to communicate with his attorney, other than when the staff came over to the jail, was on the phone. He could call his attorney anytime he had a question or anytime he had an idea about his defense. He's thinking to himself, well, maybe we should call this witness, or maybe we should do this. Better call my attorney. Oh, we should check into somebody's story that doesn't make sense. Better call my attorney. I'm sure you get the picture. Anyway, this violation of Brandon's constitutional rights could not be any more devious and nefarious. The district attorney's office had, to put it frankly, fucked up. Although, I'm not sure if they felt like they messed up because they violated a defendant's constitutional rights or because they got caught. My instinct tells me the latter. So needless to say, Jerry Davis was not happy when he heard what the head jailer had done on behalf of the district attorney's office. He immediately filed a motion to dismiss the charges against Brandon. I mean, I'm not an attorney, but it seems to me that violating someone's basic constitutional rights is a pretty big deal. After all, Judge Keli Aiken just told us that these are guaranteed rights that no government body or government official can take away from us. Most of you are probably thinking, man, they shouldn't be able to do that. Well, turns out they're not. However, the way to fix this blatant unethical violation would be a bit more complex than what you might think. Well, okay, a lot more complex. At this point, I think I can hear some of you yelling through your speakers or phone or however you're listening to me, especially those of you that have ever been incarcerated or had loved ones that were incarcerated as well. Hey, Scott, don't they announce that the calls are being recorded when you initiate the call? The answer would be yes and no. They announce to the inmate that the call is being monitored and recorded for security purposes. Most certainly not for the purposes of violating your rights by turning over your privileged conversation to the DA's office. Now, Brandon knew that he was not doing anything wrong that would cause any security concerns, so he had no expectation that any of his calls would go any further than just the security monitoring they warned about. This would become a key strategy to the prosecution's defending of their actions, and it would be wrong. If you tell me that you are borrowing my car to drive to work and back, and then you end up taking it on a weekend party trip to California, we're going to have an issue. It's the same thing. Now, if the recording would have said, "Look, inmate, anything you say may be turned over to the DA's office and they can determine if it will help convict you or not, even the privileged conversations that you have with your attorney," then they might have a point. But it didn't say that. It said they were monitoring just to make sure that you were not planning a bomb threat or anything like that. That's it. And that's all that he should have expected. Period. As I said, this all took place in July of 2007, right before they were about to go to trial. As you can imagine, this put a kink in those plans. The first thing that we have on the record regarding this is a mention of the motion to dismiss during a routine hearing on July 30th. Then they actually have a hearing on September 4th where they call Mr. Neel into court to testify as to what happened. The only thing that happens between these two hearings is a hearing on an automatic dismissal because of the violation. It's pretty boring except for one part. Jerry Spencer Davis is arguing that they have not been able to effectively represent Brandon Woodruff since the beginning of this case because the jail is in disrepair and the room that they have for the attorneys to meet with their clients is right next to the drunk tank, and you just can't hear anything. Then, out of nowhere, Jerry throws a word out that actually caught me by surprise. For those of you that don't know me, I am a lifelong logophile, if not an out-and-out verbivore. If you may not know the definition of logophile, that's probably because it's not really used often for a lover of words, but that's what I am. So when Jerry Davis threw out this word ramshackle right in the middle of an argument, let's just say I was rather impressed. It's not often that someone uses a word that I don't know. But here we are. Jerry says, quote, The Hunt County Jail is in such disrepair and ramshackle condition that attorneys can't use the phones over there. Way to go, Jerry. Way to go. You get extra bonus points for that one. Okay, so to argue this issue of a blatant and unethical violation of a defendant's constitutional rights, Jerry Davis calls in an expert in the area, Katherine Ferguson. Ms. Ferguson is what I would call a firecracker. It's very obvious when she stands up and talks in court, and I could tell this even from just reading the transcripts, that she is a no-nonsense kind of lawyer. I like those types. They're fun to watch. Here she is explaining how she got involved in the case.
I got involved in Brandon's case when Jerry called me. Brandon was charged with capital murder, but the state had waived seeking the death penalty. And in Texas, we call that a mini cap. And when the state has not waived death, there are certain requirements that for defense that have to be met. There must be 2 defense lawyers. There must be a mitigation expert. There must be an investigator and so forth. Because the state had waived the death penalty in Brandon's case, there was only one lawyer, and that was Mr. Davis. And Jerry called me because a client of my partner, Dennis Davis, had been charged with capital murder, and it came out during the trial that they had tape recorded every one of that defendant's phone calls. And then Jerry called me back and said, I think they've probably tape recorded my office's calls with Brandon. And so we started talking about it, and he asked me if I would assist him in A, finding out what happened, and then B, if they did in fact tape record his phone calls, fighting against it and trying to get some relief for Brandon on that basis. Mr. Davis, at my suggestion, filed a motion to require the state to turn over any and all tape recorded phone calls that they had received relating to Mr. Woodruff. And then when Mr. Davis listened to them, much to his horror in listening to the tapes, he would hear members of his office talking to the defendant on the phone and realizing, oh my goodness, the state has listened to these, has these in their possession. So then after they produced those discs with the phone calls on them, he called me back and asked me if I would help research what relief would be appropriate and the appropriate way to address the issue. And so I volunteered to assist Mr. Davis. I didn't become a paid member of Mr. Woodruff's defense team until well after the court had ruled that the district attorney's office had violated Mr. Woodruff's Sixth Amendment rights.
Okay, so let's talk about the hearing. I know most of you are not lawyers out there, and neither am I, although sometimes I feel like I'm playing one on the radio from time to time. But I'll try to keep the legal ease to a minimum. Let me first introduce the players. We have the judge, Richard Beacom, the 2 defense attorneys, Jerry Spencer Davis and Katherine Ferguson, and we have 2 prosecuting attorneys from the Hunt County DA's office, Noble Walker and Keli Aiken. Wait, Keli Aiken? That name sounds familiar. Very familiar. Oh yeah, we just heard from her. She's the district court judge that said the Constitution was impenetrable. Well, turns out, back in 2007, she was an assistant DA for the Hunt County. And yep, just happened to be assigned to Brandon's case. It turns out that she was the one that directed the jail to turn over all of Brandon's Sixth Amendment protected, attorney-client privileged phone calls. Wow, what a twist. I'll bet you didn't see that coming. Okay, back to the hearing. From the very beginning, it was clear that Judge Beacom was in among my friends, we call it being in a mood. Right off the bat, Ms. Ferguson calls Keli Aiken to the stand. Keli Aiken is the assistant DA that Mr. Neel said instructed him to turn over the attorney-client phone calls. Of course, Noble Walker, the co-prosecutor for the DA's office, immediately objects. There's some back and forth between Ms. Ferguson and Mr. Walker, and it finally comes down to Judge Beacom having to take over. He suggests that instead of calling Ms. Aiken to the stand first, why not just call Mr. Neel so he can say what happened? Then he would determine if Ms. Aiken needed to be called or not. Now, obviously, calling an assistant DA to the stand is a pretty unprecedented move. Of course, I would hope that violating someone's constitutional rights is pretty unprecedented as well. Initially, the DA's office, through Mr. Walker, completely deny this allegation. They said that they knew nothing about any recording of any phone calls. It's obvious that Keli Aiken got caught with her hand in the proverbial cookie jar and was just trying to snatch it out before Mom and Dad came around the corner. Knowing what I know now, it's absolutely abhorrent to me that the Hunt County DA's office would stand in front of a state district court judge and just flagrantly and unapologetically lie like that. It's either that or Keli Aiken lied to Noble Walker and he actually thought that what he was arguing was right. Either way, the unethical verbal volleyballing in this case is just absolutely unconscionable. Remember, we're not just arguing back and forth to have a conversation about the intricacies of case law. We're talking about a human being and his God-given unalienable rights that, according to Keli Aiken herself, cannot be taken away by any government official. Well, turns out she was wrong, huh? So after Judge Beacom suggests just going straight for Curtis Neel, there's some more back and forth between the attorneys, and finally, Judge Beacom says, quote, "All right, if neither of you are going to call Mr. Neel, I'm going to call him," end quote. I've never heard of a judge calling a witness, but here we are. Hunt County, Texas, ladies and gentlemen. Anyway, so Curtis Neel comes to the stand. I'll spare you the back and forth of the questions and answers, but basically, when Miss Ferguson finally called Mr. Neel, she asked him a bunch of questions about who directed him to record the phone calls, if there was any kind of special attention paid to the attorney-client phone calls, and what he did with those recordings after he made them. Mr. Neel said that there was no way for the jail to tell the difference between the regular calls and the attorney-client calls, and that he turned over all the recordings to the DA's office. Now, normally, what is supposed to happen is the jail is supposed to have a list of phone numbers that are associated with all of the attorneys in town. Office numbers, cell phone numbers, investigators' numbers, basically anyone associated with someone that might be part of the defense team. That's the way it's done in Dallas, at least. Now, let's say that one does accidentally slip through. Let's say the attorney got a new cell phone number and that number had not been registered yet. So that attorney-client phone call is accidentally sent to the DA's office. In listening to the phone calls, when the person listening realizes it's part of the legal team, they're supposed to immediately stop the recording, call the judge, and tell them what happened, and turn that call over to the defense. That way, the defense can go in and listen to what the call contained to see if there was anything that might compromise their case. Well, Ms. Aiken and the Hunt County DA's office did not do that. Not only did they not do that, but they made copies for the hapless Texas Ranger in the case, Ranger Collins. Who only knows who else they made copies for on the investigative side. Not only that, but they kept the recordings and didn't turn any of them over or alert anyone, including the judge, that they had them. The only way that Mr. Davis even knew that they had the recordings was because of the guilty conscience of the chief jailer, who did the right thing and came forward. I don't know where Mr. Neel is now, but if he's listening to this podcast, give yourself a pat on the back, Mr. Neel. A big pat on the back. So we'll wrap up the coverage of this motion with a reading of Ms. Ferguson's closing arguments to the judge, asking him to dismiss the indictment against Brandon Woodruff. It's a little bit long, but stick with it. She says a lot of things that are very important.
Your Honor, I am very dismayed and upset that I even have to be here this afternoon to argue this kind of a motion. To argue against a state deliberately intruding into the attorney privilege against a capital murder defendant and his counsel. Your Honor, we're talking about Sixth Amendment violations. What we're really talking about is as cited, or stated by the Sixth Circuit in U.S. versus Valencia, that we're concerned here with, quote, not only a Sixth Amendment constitutional contention, but also with the more comprehensive and less restrictive supervision of prosecutions to ensure that they are conducted fairly and according to civilized standards of procedure and evidence. Your Honor, I don't know how you can argue, how this court could find, that it is civilized and fair to say that you are incarcerated in the Hunt County Jail. You give up all right to be able to consult with your attorney by telephone. This is a violation of the Sixth Amendment. The attorney is only meaningful if the defendant has a right to confer with his attorney and say, well, but the attorney should just go over to the office. Your Honor, now you're dictating what the attorney has to do in representation of his client. You're telling him, well, now you just can. You have to go over to the jail every time the client needs to talk to you. That's ridiculous. And what about all the defense lawyers here? The lawyers that come from Dallas that may have the only way for them to effectively communicate with their client is by telephone. Are you telling all these defense lawyers that their clients have no constitutional right to confer with their attorneys in private? This is absurd. This is absolutely ridiculous. Federal law under 28 CFR 501.3, adopted by our Attorney General on October 31st, the government has to follow specific measures when monitoring attorney phone calls, and they cannot listen to properly placed attorney phone calls unless they have a reason to believe that the attorney is conspiring to commit a crime or some other security breach with the defendant. Well, that's obviously not here. There's been no allegation that Brandon Woodruff is a security breach. There is no waiver, and there is no reason to find that the privilege doesn't apply. These are trial planning strategies. What makes this even more distasteful is that based on the testimony of Curtis Neel, the DA's office has had some of this stuff for several months, and the only reason Mr. Davis got it is because he filed a motion about it. If he hadn't filed the motion, we may not even to this day have known that the attorney phone calls were being recorded and listened to by the district attorney's office. The proper procedure that should have been followed in this case that respects the fundamental fairness of the adversarial system and respects this man's constitutional rights is that if they didn't know the phone calls were recorded, the minute they first heard playing those tapes, the minute they first realized that there was an attorney conversation on them, they should have stopped the tape and notified this court. The only reason they listened to these tapes and didn't tell anybody about it, there can only be one reason. They were hoping to get a leg up. They were hoping to get access to how Mr. Davis and Mr. Woodruff and other members of the staff, how they perceived the relative strengths and weaknesses of the state's case and how they perceived the relative strengths and weaknesses of their own defense, what witnesses they might call, whether or not Brandon would testify. They were listening to these phone calls to get trial strategy, information about what Mr. Davis thought about the case. We can't do a fruit of the poisonous tree segregation. Why? Because it's not a little bag of cocaine that was seized illegally or a little container of pot that was seized illegally. This goes to the entire process. It is inextricably intertwined with the entirety of this case. This goes to everything. They can have gained information that will allow them to make decisions about what jury members, what potential jurors they might want to call, based on what they glean as their possible defense. Now they know and can make decisions in jury selection. Say, well, we know who the defense is going to call, so we want to look for jurors that are going to be sympathetic to this kind of defense or a witness. Strategies for attacking witnesses. Mr. Woodruff is in jail. He's been charged with a serious crime. And the state's going to say, don't dismiss the indictment because this is a serious crime, Judge. Well, Your Honor, it's because it's such a serious crime that the scrutiny needs to be applied. He's been accused of a serious crime. He still has a presumption of innocence. And to say that a pretrial detainee, who has not been convicted of a single thing to this day, has no right of privacy to consult with his attorney, that is not constitutionally sound. The Constitution requires free communication. At some point, there has to be a respect for the Constitution. This has been a gross intrusion into his privilege by the state of Texas, not only by the sheriff's office, but by the Rangers, and specifically by the Hunt County District's Attorney's Office. When there is such a gross intrusion, there's only one remedy, Your Honor. Because there is only one way that any citizen in this county is going to be able to think that we have a legal, fair, and equitable adversarial system that protects everyone's rights. Otherwise, we might as well say we're in some banana republic. Because it's actually worse than if we were in a banana republic, because we're here trying to put a veneer of, well, it's legal and it's okay on it just to violate fundamental rights. He has an absolute right to confer in private with his attorney. If this court is to give this community any comfort in the fact that everybody's rights, no matter what they're accused of, are protected and that they've got a constitutional right to a lawyer to talk to them, the only result this court can give is to dismiss this indictment, because there's no way this can be cured. It has tainted the entirety of this proceeding. Thank you.
I just have to take my hat off to Ms. Ferguson. I have heard and read a lot of arguments in court, and that was absolutely amazing. She pointed out all of the things that might seem obvious to you and me, such as, violating someone's constitutional rights is a bad thing. However, arguing this to Judge Beacom and the Hunt County DA's office was pretty much like what I would imagine talking to a brick wall would be like. One of the things that Katherine pointed out that I thought was great was that she said the DA's office was going to argue that he should not dismiss the charges because it was a serious crime. Well, of course it was a serious crime. I would hate to think that the DA's office felt like they had to break every moral and ethical rule in the realm of law to convict someone of a parking ticket. Also, one last thing. I've been telling you over and over again throughout this season that the state just didn't have any evidence to take Brandon to trial. Well, here we have another person verifying that. As Ms. Ferguson pointed out, the state was basically just embarking on a fishing expedition. They knew that they didn't have a good case, and they were just hoping that Brandon would say something to his attorneys that would give them something else to investigate. Maybe if he had actually committed the crime, this might have worked. If he was actually guilty and said something to his attorneys like, "Boy, I sure hope the state never looks in the trash can behind the dry cleaners in Royce City," and then a few days later, someone, quote, anonymously calls in a tip that there was a murder weapon in the trash can behind the dry cleaners in Royce City. Wouldn't that be convenient? Well, that's exactly what the DA's office was hoping for. Unfortunately for them, Brandon wasn't guilty and said nothing of the sort. And I hate to break it to you, but Judge Beacom did not end up dismissing the charges, even after Ms. Ferguson's excellent arguments. However, at this point, I do want to bring up the bigger issue here. Sure, the DA's office was desperately looking for a murder weapon or some physical evidence that they could use at trial, but the real damage in this case is something far more severe. Because Brandon literally had none of any of this kind of physical evidence to give up, the biggest thing that the DA's office learned was what witnesses the defense had planned to call and what certain witnesses would say about Brandon, what evidence they were planning to use in their case, etc. In a nutshell, this is called trial strategy. The defense's playbook, if you will. Imagine being the Dallas Cowboys and you went to play the San Francisco 49ers, and before you even got there, the 49ers had your book of plays. This included all of the routes you could take for each play, including what you call the plays and what players are going to run where. So as soon as Dak Prescott, the Cowboys quarterback, says blue 23 and Omaha 44, you, as the 49ers defense, knew exactly where each person was going to run to so you could go and tackle them. Now that wouldn't be fair, would it? Well, That's exactly what the Hunt County DA's office was doing. They were the 49ers. Stupid 49ers. I never liked them. I jest. If there are any 49ers fans out there, don't worry. I still love you. But anyway, I'm sure you can see why the U.S. Constitution guarantees this right. It's absolutely fundamental to a fair trial, and the Hunt County District Attorney's Office, representing the state of Texas, violated that guaranteed right. More specifically, Keli Aiken, the one who you heard from earlier that said no government official could take away any of these important rights, was the very government official that just took away that right from Brandon. Now, I want to make something very clear before we go on. Normally, you would think that once the DA's office was caught with their hand in the proverbial cookie jar, that they would immediately retreat and be kind of like, oops, my bad. In this case, they did not. They doubled down. Not only did they not apologize for the constitutional intrusion, but they went a step further and said that not only did they not commit any kind of prosecutorial misconduct, but what they did was perfectly fine. We'll get into their specific arguments when we talk about the status of the case now and where the appeals sit, but let's just say the DA's office thought that they were completely acting within the constraints of the law. Absolutely amazing. Okay, so after this hearing, the judge, of course, did not rule right away. He just took everything under advisement. One thing I did find interesting about this hearing before they actually moved on to other matters, the judge made the comment, quote, basically the court's ruling or thinking is that even if the court decides that some impropriety exists and that there is some kind of harm, that a motion to dismiss, given the nature of the charges, is too drastic a remedy. So what he's basically saying is that even if there's a constitutional violation, and even if you took the defendant's basic afforded rights given and bequeathed by the founding fathers of this great nation, that because he was charged with a serious crime, there's no way that he would dismiss the charges. What the hell? So if someone is charged with a serious crime, the state can do whatever they want because they know that there's no way that this judge would dismiss the charges. So what's preventing the DA's office from taking a few sheriff's deputies into Brandon's cell and beating the shit out of him until he confesses? Maybe break both of his arms, a skull fracture or two, maybe some bamboo up his fingernails. That'll make him confess all right. There's a reason that the Constitution prohibits this, and it prohibits the state from listening to attorney-client phone calls as well. That's just absolutely revolting that a so-called impartial judge would say something like this. If the state's actions warrant a dismissal, it should not matter if the person is charged with a parking violation or capital murder. You get caught with your hand in the cookie jar, and Uncle Scott is going to give you a spanking. The next hearing would be 1 week later, and let me just say the fireworks fly in this case. Here, I'll let you hear them for yourself. Here's a reenactment of part of that hearing taken directly from the court record. Jerry Spencer Davis, Brandon's attorney, is trying to get the judge to limit how he tells the jury that the state has elected not to seek the death penalty. His contention is that he wants the jury to not be instructed on what the punishment might be should Brandon be adjudicated guilty. The reason for this is that, according to Jerry, if the jury knows it's not a death penalty case, then they wouldn't take it as serious and would just treat it as, quote, a plain vanilla type murder case, end quote. Oh, little did he know that even before this trial began, the potential jurors would be chomping at the bit to put the small-town gay kid in the electric chair. Okay, in the clip you'll hear, first we'll hear Judge Beacom, then Jerry Spencer Davis, then the Assistant DA Noble Walker. Enjoy.
Let me clarify something. The motion is limine is how they decide, not whether they decide. Okay? I'm not limiting out that it is the state's decision. It's the process of how they do it is the subject of the limine. So it's not whether they have the power, but how they go about exercising it. That's the subject of the limine.
Well, we still maintain our objection, Your Honor, and state that this is an abuse of power with 100% discretion as to whether the district attorney has ulcers that morning, or whether he indicts for political purposes, or whether he fails to indict for monetary purposes. Maybe he's considering that the county's running out of money by all these furious capital murder indictments, where 2 lawyers are appointed, and at the last minute, even though the state is not ready, they say, oh, we're waiving the death penalty, so you lose a lawyer. Where the district attorney has an option of having 2 lawyers, a person facing a life sentence or even a death sentence, just a life sentence, at the last minute the lawyer gets dropped. And that will tie in further with our motion for a second chair, since the state has put us in a position of having to listen to and examine over 50 hours of illegal videotaping between attorney and...
Judge, I'm going to object.
Let me make my objection, please.
Fine. I'm making an objection.
Wait until I get through, and then you can address...
Judge, that's improper. He is absolutely arguing beyond any realm of decency right here. And this is hogwash, and he knows it. And I'm making an objection.
All right.
And this is indecent on the part of the state, Your Honor.
Judge, can I have a ruling?
Let's sustain. Let's stick with the issues. Let's not make speeches, and let's get into personalities. All right? I've ruled.
I'm objecting to the how part being granted by the court. I submit that's very important discretionary practice, especially under the law of parties in the state of Texas.
All right. Your exceptions noted.
Wow, wasn't that fun? Oh, what it would have been like to have been a fly on that wall. Oh well. It sure would be nice if we had recordings of those hearings. Alas, we'll just have to settle for some reenactments. But needless to say, Jerry was pretty spicy in those hearings. And very well he should have been. It's not every day that someone commits such an egregious ethical violation against your client. Well, maybe in Hunt County, but not usually anywhere else. Okay, so Judge Beacom takes the arguments under advisement, and then finally, on September 17th, about 2 weeks after the motion was heard to dismiss the charges and recuse the Hunt County DA's office, he issues a letter to both sides. I'm going to read most of the letter, but not all of it. Some of it talks about a Fourth Amendment violation argument, which is completely different than the Sixth Amendment, so I'll take those parts out, but it is going to be a little bit lengthy. However, I believe it's important to hear what the judge said in his ruling. We'll talk about it on the other side. Dear Counsel, I have done extensive reading and given much thought to the questions surrounding the district attorney's office listening to Mr. Woodruff's telephone calls with his attorney, so that there is no confusion or misinterpretation of my rulings and their reasons. I have reduced my thoughts to writing. All outgoing inmate telephone calls from the Hunt County Jail are recorded and may be monitored or listened to for security purposes. The recorded conversations are automatically erased within 90 days unless transferred to a CD by specific request. The recording equipment is not designed to decipher and not record conversations between inmates and their attorneys or defense team members. The jail phone system, if functioning correctly, has a pre-recorded message activated by the phone being answered, which warns that the conversation is being recorded for security reasons. Both the defendant, Brandon Dale Woodruff, and his attorney were aware their conversations were being recorded and possibly listened to. The situation is complicated by the Hunt County District Attorney's Office request that the Hunt County Sheriff transfer all of Mr. Woodruff's outgoing telephone calls to a CD including those calls between Mr. Woodruff and his attorney or the attorney's staff members. Jerry Spencer Davis, Mr. Woodruff's attorney, argues that although there was awareness that their telephone conversations from the jail were being recorded and might be monitored by the sheriff for security purposes, there was no expectation that the recorded conversations would be turned over to the district attorney's office to be monitored for the purposes of trial strategy, witness disclosure, or other confidential communications between attorney and client. The question then posed is, even if there is no Fourth Amendment violation, is there a Sixth Amendment violation of Mr. Woodruff's constitutional rights? Does an attorney and his client waive their Sixth Amendment privilege by discussing something of a confidential nature, knowing it is being recorded by an agency of the state for security reasons? Whether there has been a Sixth Amendment violation turns on whether or not there was an expectation of confidentiality. The expectation of the confidentiality issue is a fact-intensive determination. This is not an obvious waiver of confidentiality in which an attorney and client discuss the defendant's case in front of third parties. Because of legitimate security reasons, does an incarcerated defendant whose only means to contact his attorney is by telephone waive his expectation of confidentiality merely because he is incarcerated? Could that same argument not be made to support monitoring jail interview rooms for security purposes? The state of Texas, in the last legislative session, which ended only months ago, recognized the sanctity of the attorney-client privilege when Section 495.025 of the Government Code passed both houses by a unanimous vote. This provision mandates that the Texas Department of Corrections install a pay telephone service for confined inmates, which ensures that no confidential attorney-client communications is monitored or recorded by the Department of Corrections. If the legislature unanimously believes a convicted inmate's Sixth Amendment rights are that important, then what about those same rights for someone only accused of a crime but not yet convicted? The Sixth Amendment of the United States Constitution guarantees a criminal defendant the right to assistance of counsel. The more we as a society erode that right, the more we diminish the sense of fair play in our criminal justice system. Although the court does not believe that the office of the Hunt County District Attorney acted with malice or without some case authority to support their actions, this court believes that the practice of the state listening to a defendant's telephone conversations with his attorney is a violation of the Sixth Amendment. In a close case, we must err in favor of the defendant and the Constitution. Having decided that Mr. Woodruff's Sixth Amendment rights have been violated, the next issue is what is the appropriate remedy for such violation. The court has already determined dismissal to be inappropriate. The court, given the lack of malice and some authority to support the state's actions, likewise believes disqualification of the Hunt County attorney is an inappropriate remedy. The usual remedy, and the one appropriate in this case, for evidence obtained in violation of the defendant's constitutional rights is suppression. Consequently, any evidence obtained from any telephone calls placed by Mr. Woodruff to members of his defense team is suppressed. Any evidence obtained as a result of investigation from information obtained from such phone calls is likewise suppressed. Sincerely, Judge Richard A. Beacom, Jr. So basically, just to sum up, what he's saying is that he does find that the state violated Brandon Woodruff's constitutional rights, but is not dismissing the charges or recusing the Hunt County DA's office from the case. Eventually, after a bunch more Noble Walker versus Jerry Davis fireworks in the courtroom, the DA's office would be recused and Judge Beacom would appoint special prosecutors from the Texas State Attorney General's office. The only thing that happens after this of any significance is that they have a hearing to see who heard any of the attorney-client phone calls that the prosecution played for them. Well, do the names Morgan Lee and Michelle Lee and Ranger Collins sound familiar? Yep, you guessed it. The prosecution had learned in these calls that Michelle and Morgan were still on Brandon's side. In an attempt to turn them against Brandon, they played some of these tapes of Brandon saying some not so nice things about them. Remember, when Brandon is talking to his attorney's office, they're going over trial strategy. They want to know who is going to say what so they're not caught off guard on cross-examination. When they saw that Morgan and Michelle were on the witness list for the prosecution, of course they asked Brandon, what are they going to say about you? And when your life is on the line and you have the expectation of confidentiality, you're going to lay it all out there on the line and tell it like it is. This is no time for shenanigans. But no, he didn't say anything really bad. He still thought Morgan and Michelle were completely on his side. He just said things like, Morgan probably slept around on me while we were going out, and I don't think Michelle believes in me as much as she says she does, and things like that. So of course, Keli Aiken dragged Morgan and Michelle into the DA's office just to play these tapes for them in an attempt to turn them against Brandon. Remember earlier when we talked about that the DA listening to these calls was not just about trying to find physical evidence. This is the kind of trial strategy that they were also trying to elicit. After all, if you can take every person that's on Brandon's side and turn them against him, that's really going to help your playbook and totally destroy theirs. That, ladies and gentlemen, is why the case should have been dismissed, and the taint caused by the pursuing of those phone calls by the Hunt County District Attorney's Office could never be cured. No matter how much Judge Beacom and Noble Walker and Keli Aiken tried to pretend like it could. So after all of this back and forth legally, the DA's office finally realized that if they did stay on and prosecute the case, it would more than likely cause problems on appeal should Brandon be convicted at trial. So on October 2nd, 2007, Noble Walker finally wrote a motion to have his own office recused. The motion was granted by Judge Beacom, and he ordered that any evidence learned from those recordings would be suppressed. Now, you might just think to yourself at this moment, well, what exactly did the state learn from these calls? If you ask the state, aka Keli Aiken and Noble Walker, what they learned, they say nothing. They learned nothing. However, it then later came out that Keli Aiken had actually taken over 40 pages of notes on these calls. Wow, sounds like she learned something. Of course, Katherine Ferguson, being the astute barrister that she is, sent a subpoena to Keli Aiken to force her to turn over those notes. Judge Beacom, however, was having none of it. He simply wouldn't allow the defense to call Miss Aiken to the stand to talk about what she learned or who she talked about that information contained in those calls with, and definitely was not going to make her turn over those notes. However, what Judge Beacom did is something that still baffles me to this day. The defense wanted to know what those pages of notes said so they could determine whether or not any of the information was contained on those unethically obtained phone calls. However, Judge Beacom turned the tables on them. He told the defense that if they wanted any of the information in those notes to be suppressed, they had to tell him what the notes said. Yes, ladies and gentlemen, what he basically said was, I'm going to suppress all of the evidence on those calls, but I'm not going to allow you to know what was on the calls. But if you want any of that information suppressed, tell me what was on the calls without looking at the notes. Jeez. Do the phrases catch-22 or shooting in the dark ring a bell? I just don't understand what he was thinking. The prosecution made the argument that those notes were what they refer to in the legal world as work product. However, as Ms. Ferguson so eloquently pointed out, work product doesn't get to stay privileged when you obtain it through criminal or fraudulent means, which this definitely was. Oh well, it's only a man's life at stake. The other thing that really baffled me is that you would think that after Judge Beacom's ruling, that anyone that listened to those tapes between Brandon and his attorney would also be disqualified. Nope. Ranger Collins admitted on the stand in a pretrial hearing that he listened to at least one call between Brandon and his attorney. In fact, he even said he actually got around 150 calls that Brandon had made from the county jail, but only listened to about 7 or 8 of them. Wow. Investigation 101 there, boys and girls. When your suspect is talking on a recorded line to his friends and family, and you get all of those recordings, just throw them in the trash. Surely he didn't say anything of value. Wait, if I'm not mistaken, that sounds like a perfect time for a, wait for it, yep, you guessed it.
And now, it's time for a patent-pending Scott Pogensy personal opinion.
On a personal note, this episode took me a long time to write. Unfortunately, my head writer and partner in crime, C. Derek Miller, just didn't have the background that it took to write this episode. There were too many motions and hearings and legal arguments that he would have had to digest to make an informed script. For that reason, and so he could move on to other episodes, I bore the grunt of this week's episode. Now, don't get me wrong. I love bringing this information to you guys because it's a very, very important subject. If I ever see you at a screening of the documentary and you have questions about the Sixth Amendment violation, we are probably not going to have the time to spend hours and hours talking about it. So I'm hoping that this episode helps lay the groundwork for you to be able to wrap your head around what actually happened. Even after the dozens and dozens of hours, if not hundreds of hours, that I've spent on this one issue alone, I still only have a basic understanding of it. In fact, I wouldn't be mad at you if you had to go back and listen to this episode a couple more times just to get the whole picture. At least the whole picture as I understand it. The reason it's so complicated is because what might seem like an obvious issue to you and me is not so obvious in the eyes of the law. You and I might think that, well, if the prosecution doesn't play fair and they violate the rules, then as much as it sucks for them, the defendant gets to go free. Maybe next time they won't commit such horrid acts of violating someone's rights. Well, it's not that simple. As we'll talk about in the episode where we cover the appeals in the case, Brandon's federal appeal went all the way to the Supreme Court of the United States. There are a lot of legal arguments and interpretations to go back and forth, but again, the answer is not as cut and dry as it may seem, which is unfortunate. I'm not sure many of you want to go out and get law degrees just so we can discuss this in the way that it needs to be discussed, but I'll do my best in episode 24, just 4 weeks from now. With all of that said, my personal opinion is that the state of Texas should not have been in a position where they had to drop the charges for violating Brandon's Sixth Amendment rights. Brandon should never have been charged in the first place. The worst and most egregious fact of everything that we've talked about today is that it caused a delay of almost 2 years. At the point all of this went on, Brandon had already been in jail for almost 2 years anyway. So much for the right to a speedy trial, huh? But that's a whole nother issue. Don't get me started. But at the time all of these shenanigans were going on, the state and the defense were ready for trial. In fact, some of the hearings where they were arguing the Sixth Amendment violations, they would say after they were finished something like, Okay, well, we'll swear in the panel that we have, or should we not? They already had a panel of jurors brought in from the community to try this case. It was going to trial. But then the Sixth Amendment issue happened and the prosecutors were recused and yada, yada, yada. And it ended up causing a delay of almost 2 years. Well, guess what happened in that 2 years? Yep, you guessed it. They found the supposed murder weapon. But don't worry, next week we will talk all about the sword that they found in the barn. But for the purposes of this episode, every juror that I talked to said that if they did not have that sword, they never would have convicted Brandon. So the Sixth Amendment violation not only causes an innocent man to stay in jail for another 2 years, but also was the sole reason that he was convicted in the first place. If it wasn't for the Sixth Amendment violation, Brandon, theoretically, at least according to these jurors, never would have been convicted in the first place. And that, ladies and gentlemen, is the number one reason that this case should have been dismissed. Shame on the Hunt County DA's office for doing this in the first place, but double shame on them for arguing that after the fact, what they did was okay. Keli Aiken should be ashamed of herself, and the fact that she refuses to grant my interview and answer for her actions just shows how guilty she feels and is admitting that there is no excuse for such egregious behavior. Oh, that reminds me. We'll wrap up this episode with a fun encounter that I had with now Judge Aiken at the same reading of that Declaration of Independence I talked about earlier. As soon as I asked her how important the Constitution was and should be to all of us, I broke it to her that I was the one doing the documentary about the Brandon Woodruff case and that I've been sending her interview requests that have been ignored. Here's how that went down. If you're not watching on YouTube, you might want to. A picture is worth 1,000 words. Enjoy. And also, so I'm producing a documentary about the Brandon Woodruff case, and I sent you a request to ask some questions of you. Can you sit down for an interview, or can we talk about the case? Is there any, Judge Aiken? Is there anything that we can talk about that case? I mean, did you infringe on his constitutional rights? Guess you didn't like that. All right. Please join us next week when we talk about why the alleged murder weapon was definitely not the murder weapon. And I don't mean that it was the murder weapon, but there's no way that Brandon could have used it. No, I mean that I'll forensically prove to you next week that this sword they found was not and could not have been the murder weapon. Until then, remember to stay aware, stay strong, and get involved. See you then.
One of the things the state tried to argue was that dagger, they called it, I called it a sword, that was found 2 years later in the Heath residence, had up in the hilt area, there was just a tiny amount of Mr. Woodruff's blood, Brandon's father's blood. And so they said, aha, this is the knife that killed him, and here's the blood from his father to prove it. Well, there's such a small amount of blood there, and they said, well, he could have washed the knife. Okay, so he has magic water that only washes away his father's or his mother's DNA and blood evidence, but leaves enough of his father's behind, or doesn't leave a mixture of his mother or his father, it just leaves his father's behind. But he can miraculously clean up all possible traces of any kind of DNA on his cell phone that he's allegedly on back and forth during the time of the murders. And they said, well, the phones went to voicemail. The calls were less than a minute. They went to voicemail, but that still requires you to pick up the phone, dial, listen to a message, and either leave a message or hang up, and then pick up the phone again and call again. So there is still time involved in the physical process of initiating a call.